More text messages from around the time of the January 6th insurrection are missing, conveniently, from a third government agency. This time, it's the Department of Defense. Texts and emails from top Pentagon officials who would have been in charge of mobilizing the National Guard, including former Defense Secretary Christopher Miller and Army Secretary Ryan McCarthy, but also other more controversial figures like last-minute Pentagon appointee and Trump loyalist Kash Patel, former Pentagon Chief of Staff. According to a federal court filing, the Pentagon and the Army said that when an employee leaves the Pentagon and turns in their phone, the phone is wiped, and text messages from around the attack were, quote, not preserved and therefore could not be searched. The government watchdog group American Oversight sued for the records and is asking Attorney General Merrick Garland to open an investigation into the Pentagon's failure. Senate Judiciary Committee Chair Dick Durbin has also called on Garland to investigate wiped texts from the Secret Service and the Department of Homeland Security. The investigation into missing Secret Service texts is now a criminal investigation, but top Democrats want the Trump-appointed DHS Inspector General to step aside from that investigation since he knew about the erased text months before he told Congress. Joining me now, Richard Painter, former chief White House ethics lawyer in the George W. Bush administration and professor of law at the University of Minnesota, and Charles Coleman Jr., a civil rights attorney and former prosecutor. Thank you both for being here. Richard, I'm going to start with you. Michael Beschloss has said, and I once thought an 18-and-a-half-minute gap was a big deal. Important to strictly enforce all existing U.S. laws requiring preservation of presidential and other federal records, essential if we want to keep our democracy. It does not seem possible for it to be coincidental, at least to me, that three agencies deleted, wiped their phones and didn't think to preserve the records from January 5th and 6th. Does it seem possibly coincidental to you?
Doesn't sound coincidental to me. It sounds intentional. And I will tell you exactly what I told the White House staff, and I was the chief ethics lawyer in 2005 to 7 about preservation of government records. It is a felony under 18 United States Code, Section 2071, to engage in concealment, removal, or mutilation of any government record. That is a felony. And every White House instructs its staff, as well as the agencies, that when you leave the government, the only messages or other communications that you can remove from the premises or destroy are your personal communications about your personal business, not the response to January 6, 2021, or any other official document. This is a felony under numerous statutes. I heard rumors that there was going to be destruction of government documents during the Trump administration, at the end of the administration in November 2020, within days of the election. And I wrote an op-ed for the blog Just Security, outlining all of the statutes, letting people know that if you destroy those documents, government records, including text, you will go to jail. And now we have also obstruction of justice, because once January 6, 2021 happened, we know that there were criminal investigations of who incited this riot. And so not only do we have destruction of government documents, but obstruction of justice in not one, but three government agencies. And I strongly suspect that the orders for the destruction of this evidence came from the White House and perhaps from the President of the United States himself.
And, Charles, it's not as if the Trump administration had a good history when it came to preserving records. Let's just go through it a little bit. January 6th White House logs given to the House show a 7-hour gap, which is what Michael Beschloss was talking about, in the Trump phone calls that day. Now, the National Archives says that Trump took 15 boxes of White House records to Mar-a-Lago in Florida. Trump flushed, per NBC News, or just lost documents, including allegedly swallowing some of them. The White House is refusing to release its had refused to release its visitor logs from the very beginning. That's from January of 2017 on. They've always been secretive. They've never handed over records. This is a pattern. And so to you, as a former prosecutor, could it possibly be just a coincidence that no one thought to preserve the records from the 5th and the 6th from these three agencies before allowing the phones to be wiped?
Well, Joy, I think the more that we look at this, it becomes increasingly obvious that it's not likely to be coincidental nor accidental that you have three agencies now where these messages are missing from the same time period. This certainly appears to be a very intentional effort. And I think that in many respects, it's a gamble that officials were taking because in most cases, prosecutors are not necessarily going to pursue something like this under normal circumstances. Had January 6th not happened and certain records been missing, it is not likely that the DOJ is bound to open up a huge investigation in terms of trying to ascertain the intentional destruction of certain records. But because January 6th did happen, now you have something that is monumental and historic and of such a huge magnitude that the DOJ is almost compelled to look into it vis-a-vis a criminal probe. And so I think that's the issue here is that normally something of this nature, even though it is criminal, might not rise to the level of getting prosecutors' attention. But given all of the implications that it has in this case with respect to January 6th and everything that may have taken place to cover up what we don't even know because we haven't seen the text messages, it becomes that much more imperative that the DOJ make this a priority.
Very quickly, I'm going to ask each of you first, starting with you, Charles, the significance in your view of Pat Cipollone being called by a grand jury, being subpoenaed by a grand jury.
Well, it doesn't look good for Trump, I'll tell you that much. I think that it's very clear that the DOJ is focusing their efforts on trying to identify as much as they can people who have direct knowledge of Trump's actions, his thoughts, and can give them as much information as possible. It does remain to be seen, however, how Cipollone will cooperate with this grand jury subpoena. Remember, when he testified in front of the January 6th committee, there were a number of different provisions that helped him avoid executive privilege and other things of that nature. Without those things in place, it's not clear how he's going to respond to the subpoena when he actually shows up.
Richard Painter, I mean, what do you make of the ethics of his need to be subpoenaed in order to turn over information about an insurrection against our country?
Well, it is abundantly clear that the White House counsel has no privilege with the president that can't be waived by the Justice Department. We went through that with President Clinton. So there's no attorney-client privilege here that can be kept secret from a grand jury. And there's an obligation here for him to testify, for the White House counsel to testify truthfully about what happened. And I believe he will. He repeatedly advised President Trump not to engage in insurrection and sedition up to and including January 6th. President Trump clearly ignored that advice. And that is going to be admissible evidence against President Trump in a criminal trial. He is not President Trump's personal attorney. He is an attorney for the United States government for the office of the presidency.